let's get going. Welcome everybody, and thank you for attending this anti-money laundering webinar. And a massive thank you to Gordon Kerr, our strategic consultant for legal. This webinar is going to be recorded, and we will send out the recording to everyone who's attended and who's signed up for the webinar. So if you do need to duck out at any point, then don't worry, you won't miss anything. We're scheduled to run for an hour, but we have got some extra time if needed at the end if you do have lots and lots of questions. As far as questions go, Gordon's very happy to answer those as we go along. You should notice there's a Q&A box at the bottom of your screen. If you just type your question in there, and then I will raise that with Gordon as we go along. And I think that is everything that I need to say. So I will swiftly pass you over to Gordon.
Thanks very much, Bryony, or Dominic, as it says on the screen here. So. But it's a big improvement. Yeah, welcome everyone. Thanks for joining this session. For those who don't know me, my background is a lawyer. I spent many decades in the relocation industry, initially with my own business, literally as managing director of Team Relocations, now part of Serva. And what I try to bring to these legal sessions is a combination of the technical side of the law, but also how in practice it operates within our sector. You know, what does it mean in practice for relocation businesses? And today it's anti-money laundering. So let me move on and just see. Oh, that's rather annoying. We don't seem to be, the slides don't seem to be moving on. Any idea, Bryony, why that should be? It's showing me as screen sharing. You're obviously, are you seeing just the first opening slide still?
Yes, at the moment.
Okay, that is a little bit annoying. I wonder if we can. I'm going to just briefly stop share and see if I can fix that in the background. So apologies, everyone. Okay, it's moving on my screen.
Do you want to try again?
Yeah, let's. No, okay, I'm gonna have to move these on manually then. Okay, I'm going to stop sharing just for a second. I'll just move it on. Fortunately, there are only about 10 slides, so okay. Right, Brian, are you now seeing my second slide?
Yes.
Yeah, great, okay. At most it may be a wee bit clunky as I move slides. I've no idea why we have a problem with it. It's never arisen before. But anyway, right, getting into anti-money laundering and how it's regulated. Just to go really into the basics here, money laundering is the process where you take proceeds of crime and you channel it through a legitimate source, and it comes out the other end as clean funds. And traditionally, that's related to organized crime, or corrupt officials, but it can be even as basic as someone who's committing tax evasion, they're not paying their tax. If you act for somebody in that category, that too is money laundering. And it really goes way back to 1920s, 1930s, days of Al Capone. They couldn't catch him or convict him on racketeering and murder. And eventually they got him for tax evasion. And that started the whole issue of following the money for crimes. You may not be able to convict somebody of the crime they've committed, but you can follow the money and convict them for moving and trying to launder their ill-gotten gains. And it then was extended after the 9/11 terrorist attacks to include any funding raised by terrorists. And today, it tends to be in the headlines for banking scandals. I think HSBC and Paribas were also fined. And these can be like billion-pound fines. So huge fines for not having systems in place to prevent money laundering. So we have 5 EU directives so far. It's a kind of continuing issue of new legislation coming out as criminals come up with new ways of laundering their funds. So that's why I would describe it as a continuing battle. And these EU directives are then put into national legislation. So each country in the EU and the UK translates it into legislation specifically for that country. Now, it's a little bit of an irony that despite Brexit, in fact, we still follow EU rules, and we've actually interpreted them more strictly than any EU country. And that's why relocation businesses are covered by anti-money laundering in the UK. But if you run a relocation business in France or Germany, then unless you're handling large sums of cash, regulation doesn't affect you. So it does seem a little bit strange, but there it is. The UK has ended up with rules that apply to the relocation sector. And that is why, of course, we need to be very familiar with these rules and be complying with them. So let me delve into how the rules operate. And again, I'm going to have to, come out of screen sharing and move the slide on. Again, Bryony, is that come up okay?
Yeah,
great.
All good.
Okay, so what is the regulation that affects UK relocation businesses? There are really 2 categories that are brought in. If you carry out home search services for buyers, so if you're a buyer's agent, home finder, then the rules have really applied to you for a number of years because relocation businesses were classified as part of estate agency rules for money laundering purposes. So that's why it's been in place for a few years. But more recently, rental home search has been included under letting agents if the monthly rent exceeds 10,000 euros. And again, it seems strange that it's quoted in euros, but that's because it's come from EU legislation. So if your relocation business either does purchase home search or ever does rental home search where the rent exceeds 10,000 euros a month, then you need to be regulated for anti-money laundering purposes, and you need to register with HMRC. And we'll talk in a moment about what exactly that means. The law on this, just in case anyone loves reading legislation, it's two pieces of legislation. The Proceeds of Crime Act of 2002, that sets out all the money laundering offences. So if you are actually money laundering deliberately, that's where the offences are found. But more particularly for our purposes, the regulations of 2017 contain the details of what must and must not be done by businesses that are regulated. And these were, I think, last updated. There were some amendments in 2019 as well. But the basic rules are in these 2017 regulations. Now, on the assumption you don't like reading legislation, HMRC, who are the regulator for the UK for money laundering, have come up with a number of guides, some more useful than others. And there are three main ones. The July 2022 guidelines, which is on anti-money laundering supervision, estate agency and letting agency businesses. That's about 76 pages long. It goes into great detail on things you should and should not be doing if you're an estate agent or a letting business. It refers at 1 or 2 points to relocation businesses, but for our purposes, if you are acting for a potential renter, then you come under the letting agency rules. If you're acting for a potential purchaser of property, you come under the estate agency rules. And it's all in there in a huge amount of detail. There's loads of repetition. They were originally estate agency guidelines, and then they just lumped letting agency guidelines into it as well. So it's a pretty painful read, but as I say, all the detail is there. And then just last October, they brought out another set of guidelines, which is about helping businesses to understand the risks to their business from money launderers. And that's a short, I think it's about 6 pages with some very useful guidance on how your business should understand the risks around them. And that's what we're going to be talking about in a moment. And then we have the anti-money laundering webinar for letting agents, which I think was 2020. That was done just when the new rules were coming out, bringing relocation firms under the letting agency rules. And that's a 1-hour webinar, which actually is quite reasonable. It's a couple of people from HMRC talking about how the rules apply in practice and what businesses should be doing. So if you're looking for more information, these are the sources I would use. And so, yeah.
Sorry, Gordon, I do just have a question regarding these. Someone has asked if you're able to supply links to these documents and the webinar at all.
Absolutely. I think on the assumption, Bryony, that we're issuing everyone with a set of slides, I'll provide you with the specific links for these, and that can be sent out to everyone. Yeah, that's a good point.
Thank you.
Okay, apologies again, folks. I'm going to have to stop share for a second and move the slides on. Oh, I don't think that's moved on.
No.
Sorry, let's try again.
That one, I think it did then.
Okay, has it come up now?
If you share the screen again. Yeah, there we go. Perfect.
Okay. Yeah. Right. So if you fall into one of these two categories, the high-end rentals or you're doing purchase home search, what does it mean in practice? And this slide really is just a summary of what a relocation business should be doing. So firstly, if you fall into either of these categories, you have to register with HMRC. So you go onto their website and you complete the registration and you pay the fee. I think it's currently about £300 a year to be registered. It's meant to be self-financing. And then there are these 6 items that you need to be able to tick the box on each of these. Firstly, there should be a risk assessment for your business. And I'm going to go into each of these in more detail in a moment. So let me just summarize firstly the big picture. So you prepare a risk assessment. You then have to prepare a written statement of your anti-money laundering policy and what your procedures are. Again, I'll be going into more detail on that. You have to have checks in place to carry out customer due diligence. So every time you take on a new client and before you start working for that client, and that's quite an important point. Questions often arise, well, can I catch up on doing the checks on a new client while I'm starting work? The legal answer, the technical answer is no. You have to have satisfied yourself as to the identity of that individual before you start carrying out any work for them. That's what the rules say. You have to have a staff training plan. That means that certainly for a new member of staff, their induction should include some training on anti-money laundering and perhaps annual training for all your staff who could encounter anti-money laundering. You need to work out which members of staff are relevant for that purpose. You need to appoint a reporting officer. So that's somebody senior in your organization who can take an overview of your compliance. And in particular, if anything suspicious does arise, and again, I'll come back with some examples of that, then that individual has to decide, should we be reporting our suspicions to the National Crime Agency? So you need that individual. Every business that's regulated with HMRC has to have a reporting officer. And you have to keep written records of all this. Now, partly that's because the HMRC supervision includes audits, and it's certainly quite common to find that they will target relocation businesses. I know a number of relocation firms that have had audits carried out by HMRC. So this is important that you have records and you have records that are up to date. And they can actually hold managers, senior managers in a business personally liable if they find that there have been compliance failures. Again, more on that in a moment. So I'm going to delve into each of these 6 issues and see what they mean in practice. Now, let's see, it may have...
I do have another question, Gordon.
Yeah.
Would registration with HMRC for the anti-money laundering be needed if payments are actually made via a third-party bill payer?
Yeah, so it's got nothing to do with payments in the UK. Our rules say that if you have a client who is a renter, again, above 10,000 a month, or a purchaser, doesn't matter that you're not handling any money, you still must register. Yeah.
Okay, thank you. And another question, what are the size of fines for non-compliance?
We've got quite a picture now of what HMRC are doing with small estate agents, for example. The average is probably between £5,000 and £10,000. I think the last report I saw from HMRC was something like the headline was they had charged businesses and raised over 500,000, £500,000 in fines, but that was split over about 80 businesses. So they tend to pick up on estate agents, small firms who maybe are just totally ignoring the rules. So that's, you know, they just haven't registered at all. I think the only one that I saw that was more significant than that, there was somebody, a small estate agent in London. I hadn't heard the name, but the guy was given community service, 120 hours of community service for not registering with HMRC. So yeah, I mean, it's serious enough. Yeah, but it's not obviously the $1 billion that the big banks have been fined.
Okay, I have another question. When you say client must be checked before starting work, is that the corporate client or the assignee or both?
Yeah, it's the individual that you are delivering the services to. So if you are again, it has to be put in the context. If it's a relocation, you've got a corporate client, and it's the individual that you're looking after and doing rental home search for, it's that individual that is the one that matters, because they are becoming the tenant of the property, I'm assuming. If it's the corporate client who's becoming the tenant, that's an interesting one. Yeah, you would, in that case, show in your records that your corporate client had been identified. But identifying a corporate client is usually a fairly simple process. You know, if they're a publicly registered company, then, you know, on the stock exchange, you can just identify them from their listings. The tricky ones really are individuals. But yeah, so whoever the tenant or the buyer is going to be, that's the name that matters for money laundering purposes.
Okay, so I think you've just answered one of the other questions. When the client is a company and they are paying the rent, so I think you've just spoken to that.
It's more to do with who's the tenant, who's going to be the tenant. But I mean, the great thing, if it was just a corporate client you were dealing with and they were the tenant and they were paying the rent, etc., then of course you're only having to do that once for that company. So it's a lot easier again than every time you have a new assignee having to do the checks on them. So
right, this is generating a lot of questions. We get the information on the actual assignee before making an offer. Do we need to do it sooner?
You're getting yeah, so as soon as you are making an offer for an individual, you should be carrying out identity checks then. So in other words, the law would say you cannot put forward an offer for a property without having already identified the individual and carried out the checks. So that's clear. But going further back, if you are contacted, let's say by a private individual, it's a private case, then you shouldn't do any work for them at all. You shouldn't be starting your home search service for them until you've carried out identity checks. So that's what the law says.
Okay, and next we have carrying out checks on individual expats makes it extremely challenging to carry out AML when you have thousands of expats.
Yeah, well, of course, you're only carrying out, so this is you as a relocation business dealing, I mean, if it's a group of individuals, like a group move coming in, then that's quite right. You would be having to identify each of these individuals. And maybe if I move on that, because I'm going to talk a little bit about what that customer due diligence looks like, because it really comes down to the details of, well, what do you actually have to do and how difficult it is? And there are some situations where that's going to be very straightforward, and others where it's a little bit more complicated.
Okay, so there's 2 more questions that have been entered. So if I just ask, and if you're going to cover them later, then we can move on. But the next one is, if the instruction for the search comes to us from an RMC, are they responsible for the due diligence? And if so, do we need to get confirmation checks have been done, or is the responsibility ours?
Okay, the legal responsibility is yours. The relocation business that's actually handling the case. Now, what you can do, if the relocation management company is also regulated, and if they have carried out the checks themselves, then you can rely on their checks. But you would still need copies of the identity documents on file for reasons I'll come to. You know, if you're audited, you have to show. So it's not enough to say, oh, we were acting for an RMC, therefore we didn't need to do the checks. You still need the evidence of that on your file. And again, that should be an example where there shouldn't really be a problem. Relocation management companies obviously should be very much alive to what these rules are, and there shouldn't be a problem in getting the kind of documentation that's required. But I appreciate it's easy for me to say that. Yeah. I'm sure there are situations where it's harder in practice.
And the final question before you move on. Oh, actually, that's just prompted another question. What about GDPR rules about holding copies of individual identity checks?
Yeah, so what the GDPR says is that there has to be a lawful basis for retaining someone's personal data. And here there is a clear lawful basis. The law says that you as a business must hold on to that data. And in fact, it's very specific that you have to hold it for a minimum of 5 years and a maximum of 10 years. So if you've got a general policy, for example, of holding on to data for 7 years, then that fits in very neatly with it. Okay. And if the individual says to you, we object to you holding our data, you know, you've now checked us out, please delete it, you are entitled to refuse that request. So, and in fact, you have to for your own legal purposes. Again, if you're audited, you can't say, oh, the customer insisted that I delete that. That would then be an error by you in law, because you're legally required to hold that data for 5 years.
So anti-money laundering trumps GDPR in that instance?
Yeah, exactly. Yes, yes.
Okay, so the final question, and then I will allow you to move on. Do you need to do a customer due diligence on each customer, even though the rent is well below 10,000, or is it only applicable?
Yeah, that's a good question, and it's one that I had when these new rules came out. And I am reliably advised, and everything I've read on this is that it's only the individual cases where the rent is actually in excess of 10,000 euros per month. So, yeah. And now you may decide that it's good practice to do customer due diligence, but you're certainly not legally required. If it's 5,000 a month, then these cases don't fall under the regulation. Okay. Which I'm sure is a big relief to everyone, because had you be having to do this, you know, on all cases, I appreciate it really is quite an admin burden, and particularly galling when we're the only country in Europe that does these checks. Shall I move on, Bryony?
Yes, please do.
And has the slide come up okay?
Yes, it has.
Excellent. Okay, so I'm just going to run through these 6 points in a little bit more detail. Though in fact, some of the Q&As have probably covered these points. So firstly, assessing the risk to your business. Now, this is completely separate from looking at the risk of an individual transaction. This is your business as it stands today. What are the risks from money laundering? And there are 3 things you need to look at and note down for audit purposes. Firstly, what kind of clients do you handle? So there's at the high risk end of the spectrum, if you have a lot of foreign clients who buy property high end in London, then you would be identifying that as a high risk. If, on the other hand, your only clients are coming through relocation management companies or direct from corporates, well-known names, and it's clearly in the context of relocation, it's in the context of 2-year, 3-year, 5-year assignments, then you would be identifying these as low risk. Then what kind of services do you offer? Well, again, if it's in the context of relocation moves, and that's all, then that would be seen again as low risk. If you are focused on central London and particularly high-end properties, then you would identify that as high risk, and you'd be expected to be more vigilant than somebody operating in the low risk area. And then the third point is about funds. Do funds actually pass through your business? Now, if the only funds that come in are relating to your own fees, issuing your own invoices, then that again is low risk. But if you regularly receive large sums of money for deposits, first month's rent, first quarter's rent, then you're moving into higher risk areas. So the idea is you look at your business, and in the context of your clients, your services, and your handling of funds, you identify what are the practical risks to your business, and are these high risk or low risk? And again, that HMRC document I mentioned earlier goes into a lot of detail about assessing risk to your business. And in fact, the most recent one is specifically on that. This is understanding risks and taking action, letting agency businesses, which of course includes relocation firms. So there's a lot of stuff on that, but it's important that you have this document that sets out how you see the risk to your business. Second thing you have to do is create a money laundering policy for your business. I just run off a typical one here. This is in the context of a law firm, and you can see it's headed anti-money laundering policies and procedures, the version number, etc. And it starts with an overview, and it's worth just, I'll read out this first sentence. Firm name, Smith & Co. Take a zero tolerance approach to being involved in illegal, illicit activity, and will fully comply with all relevant sections of the money laundering regulations and the Proceeds of Crime Act. So they set that out as a statement, and then they go into detail, lots of bullet points about how they do that. And that's really the next few points I'm going to cover, because it's things like customer due diligence, it's about training, it's about identifying any real suspicious activities on the part of a customer. So you need that policy in place. And then the third thing is the one that probably causes most hassles for relocation firms, customer due diligence. So we've identified, we're talking about the individual who's going to be the tenant, who is the person who's entering the property transaction. And you need two forms of ID, one photographic, typically a passport, and the other would be something that identified the individual's address, so typically a utilities bill within the last 3 months. And I think people are used to that now. We have to provide these in all kinds of situations, not least opening a bank account. So two forms of ID. And again, the HMRC document goes into lots of details about, well, if you can't get a passport, use a driving license, etc., and all the things you can use for that. Now, this assumes that you're meeting the individual and they're producing these two documents. You're taking photocopies for the file, and excuse me, that's all very straightforward. But obviously there'll be lots of cases too where you're not meeting the individual, and in that case you obtain certified copies of these documents. And typically that would be certified as a true copy by a solicitor, an accountant, someone in a bank, the kind of person who can certify a passport application, can certify copies for you. You're meant to take a special enhanced due diligence checks if you ever come across what are called politically exposed persons. Now, if I look at what that means according to HMRC in the document, it's people like, if you ever act for a head of state, a minister, a deputy or assistant minister, member of parliament, member of the Supreme Court, ambassadors, high-ranking officers in the armed forces, etc. It's really people who, particularly in a foreign context, may have access to their national government funds and maybe using these funds illegally to purchase property, for example. So politically exposed persons, additional checks have to be carried out on them. And again, the kinds of checks, and that can be everything from Googling them, making sure you're clear about the information on them, and other information. If somebody is high profile, there should be lots of information out there that you can get on the web, and you're expected to do that. Again, in the context of relocation, it's unlikely, but if you are a buyer's agent, then you may come across occasionally somebody who would be defined as a politically exposed person.
We do have a question that's kind of linked to that. If the assignee has diplomatic status, are AML checks still required?
Yeah, yes. I don't think there's any way around that, and so it would be almost the opposite. Yeah, you have to carry out these enhanced checks.
Yeah.
I can't, obviously, if somebody at ambassador rank is saying, I can't provide these checks, or, you know, there's some legal reason, then they would have to give you exactly what that legal reason is. But I can't, you know, offhand think why there would be an exception, and you would be in real danger if you didn't do checks and somebody who said, oh, because I've got diplomatic status, you don't need to check me out. That would almost fall into the category of suspicious activity. So, yeah.
And just another question around certified copies. Do they need to be certified in the UK, or are copies certified in the departure country acceptable with translation if needed?
Yeah, so certified in the foreign country and would be fine, as long as you were satisfied that this was certified, for example, by a lawyer in that country, and, you know, was done under their stamp, that kind of thing. Yeah, I mean, we rely on foreign notaries a lot for documentation. So in principle, there's no problem. But yeah, you would be having to look at the documents carefully. And if you had any doubts at all, then having them redone in the UK would be the solution. But yeah, there's not a point of principle there about that.
Okay, thank you.
Okay. The final point I'll make about customer due diligence, and this is one that I think is a bit messy. What the law says is that if you are acting, let's say, for a potential renter, then you also need to see the identity checks on the landlord. If you're acting for a buyer, then you need to see the identity checks on the seller of that property. And again, there's a lot of stuff about this in the HMRC guidelines, Their idea is that if you're acting for a renter, then the letting agent should share with you the information that they've obtained on the landlord and provide you with copies of that and say specifically that you can rely on the identity checks they've carried out. And similarly, acting for a purchaser, the estate agent should share with you the information they've already obtained, so you're not having to duplicate it. Now, I know from a previous meeting I had, a number of relocation businesses were present. Some letting agents and estate agents were good about this and would share, and others were being very difficult. And this was in the early days of the legislation. So I'm hoping it's settled down, but I will be very interested to hear if businesses which have already registered are having issues with agents. So for example, are Savills to share the identity of their client? Now, by law, if you're entering a lease, the landlord's name and address have to be divulged to you. So it's really a case of, like, can you also get the identity documents that, let's say, Savills obtained on that individual? If so, fantastic. If not, then there's still an obligation on you to be satisfied as to the identity of the landlord. So you will have their name and address, and, for example, carry out a Google check. If you carried out a Google check with my name and address, there would be enough information there to show that, yes, I did exist. I was a legitimate individual. But whether that works in all cases, I don't know. So it's a case of doing what you can if the agent is not being cooperative with you. But as I say, I'll be very interested on feedback on that and how things have been in the last year or so, whether agents are being cooperative.
Unsurprising, there's a couple of questions this one has raised. So do we actually have to see the agent's identity checks, or is it okay to just have their assurance that they have done them and you can rely on that information?
Yeah, I'm pretty sure that in the guidelines, it says that you should see copies of the documents and hold these on your file. Now, this is where, as I say, it gets a little bit tricky. If that agent says, no, we're not prepared to share, or our client doesn't consent to sharing these documents, then what you would do is, yeah, you'd ask the question, you know, have you seen identity checks? Have you carried out identity checks? And are you satisfied as an agent? In which case you would note that on your file, but you would then want to do some kind of follow-up with their name and address and just see what you can find out about that individual. And, you know, is there anything suspicious? I think if you don't know your client, if it's not a normal relocation, if it's an individual that you've never met before, what we're trying to prevent here is effectively like a criminal conspiracy. It's a sham landlord and tenant arrangement that's being set up here. And it's just being used to move funds. So if you don't know your client, you know, other than getting the basic details on them, and you don't know anything about the landlord, then that's where you maybe feel a bit less comfortable. But in the context of normal relocation activity, you know, all you can do is what you can do, and make sure you note it on the file. And if you are audited, you can explain exactly, you know, what the situation was and why you didn't regard it as a real risk.
Okay, I think that's answered one of the extra questions. Then we've also got agents don't appear to be keen to share the actual information, but I think you've answered that question. And then, would you still be required to check the seller's details if you are not involved in the offer, you're only attending viewings with the assignee?
So this is in the context of a letting. You've not submitted the offer, so I'm assuming it's gone back to the RMC, for example, or I suppose the individual could be doing it themselves. If you have just done viewings and you have no contact with the letting agent, then it probably does get you off the hook. It depends when your service has ended. You know, if my sole service to you, Bryony, is to take you out for a day's viewings, and
Yeah.
you choose which one you want, and you're then taking it forward from there, then I can't see that there would be any requirement on the relocation, on me as a relocation business, to be getting details of the landlord. Yeah.
Okay, and that would be the same in the case of a purchase of a property.
Yes, if all that happened, it's important, when does your service end? And if your service ends before an offer is going in, then I think I would be reasonably comfortable about that. But you know, you've got to be careful. Am I bending the rules here? And if in doubt, you should always at least ask the agent on the other side for the identity information.
Okay, thank you.
Okay. The system, by the way, seems to be moving on the slides okay now.
Yeah.
Does that come up okay?
Yeah. Yeah.
We just needed to speak to it nicely. Okay, staff training. So the whole idea is you can't just have these policies and procedures gathering dust on a shelf. Your staff and all the staff who are sort of client facing have to be aware of what the rules are, what identity checks have to be carried out, what are suspicious circumstances. I mean, obviously a clear cut being if a new client wanders into your office with a bag of money, clearly that's a suspicious circumstances, or there's no kind of no logic to what is happening here. It just seems all very artificial. So staff have to be trained on these issues and trained in your particular procedures. So obviously this session is about what is the law and how does it apply to relocation businesses. You're then having to go down a level into the nitty-gritty with your staff of this is exactly what we want you to do to identify individuals. This is what we want you to do if something suspicious happens, etc.
Okay, so they can just, staff can't just be given this training to watch, for example, and then you can tick that box. They could watch this, but then they'd also have to go through your specific processes as well.
Exactly, because when you think about it, it would be kind of crazy if they knew what the law was, but had never read the policy document for your individual firm. So yeah, great if this can be used for staff training in the sense of here is the law, but yeah, they would need to familiarize themselves and be given help in what actually went on in your office. I mean, when I rejoined a law firm probably about 6 or 7 years ago, after having been out of law for some time, the first thing I had to do was sit an anti-money laundering exam for the firm, and you had to get a pass rate, I think, of 70%. And that was every single member of staff, new member of staff in that law firm, whether they were an experienced lawyer like me or, you know, a new PA coming into the office, everybody had to do the exam. So it's, you know, law firms obviously treat it very seriously, but now relocation firms have to treat it just as seriously.
Yeah.
The fifth point was about having somebody senior in your firm who is appointed as the money laundering reporting officer. And that individual is the person that members of staff, more junior members of staff, will go to if they're uncomfortable about any transaction that's going on or something suspicious has arisen. Then you need a senior person to make that assessment of, is this, I'm completely comfortable with this, or this is something I need to report to the National Crime Agency. So you can't just leave it to individual members of staff to make these kind of big decisions. I mean, I was the anti-money laundering partner in a law firm many, many years ago when the rules first came out. And we encouraged staff to fire anything that was in the slightest bit suspicious to me, and maybe only 1 in 10, 20 cases would I then seriously consider that something needed reporting to the National Crime Agency. And yeah, probably over a period of 2 or 3 years, I think I only made 1, maybe 2 reports to the agency. So, but you need that system in place. And you have to keep records, as we touched on already, a minimum period of 5 years, maximum of 10 years. And yes, it does override GDPR. And when you're audited by HMRC, they will want to see these records. And if if you don't have them, then you're immediately failing your audit.
We have a couple of questions that were based on things that you've already talked about. Would you like me to ask you those now, or do you want to come back to those and do a sweep up at the end?
No, carry on, yeah.
Okay, so going back to the €10,000 per month.
Yeah.
So if the rent increases and becomes over 10,000 per calendar month, do the checks then apply?
Yes, good. That's a very good point, because what HMRC say is that if it's just under €10,000, whatever that is in sterling terms on the day in question, you should be building in the fact that if there's going to be a rent review after 2 years or whatever it is, that could push it over the 10,000, and therefore you should do the checks up front. Yeah. But
Right.
definitely, if you've not done the checks up front and it does go over the €10,000, yeah, you would have to do the checks then.
And I think this one we've kind of covered, but just to clarify, if we're not doing the home search but only the tenancy negotiations, do we have to do the AML checks when the rent is over 10,000 a month?
So it's all about the definition of a letting agent. So what brings a relocation business in is because you are acting for a tenant, and your service to that tenant is to find a property. So if you are not doing home finding for that individual, and you're just doing a lease check, for example, then no, I don't think that would bring you under. If it's just lease checking, I can't see. I'd need to look carefully at the definition, but my instinct would be no. That's not the work of a letting agent as defined in the legislation. It's this idea of you acting for an individual in the process of helping them to find a property. That's kind of how it's defined in layman's language.
Okay, and so do the checks have to be done before an offer is placed?
Yeah. Really, as soon as you are wanting to open a file on the client, yeah, the checks have to be really upfront. It's such an important point, and HMRC stress that you cannot take on a client without doing the checks.
Okay, and what if the individual stays in serviced accommodation that is over 10,000 a month?
I can't see that making any difference. If it's serviced accommodation, obviously it's a commercial landlord, so that side of it should be easier. But in terms of carrying out identity checks on your client, you are introducing them to a property. The only thing is it has to be for at least a month. So if it was only for 2 weeks, it would be okay. But yeah, at least a month.
Okay, perfect. That's
good.
all I have at the moment. Thank you.
Right. I wanted to finish looking at the audit because, again, it's almost like looking back in deciding what you need to have in place. One factor in that is what would ensure that we had a comfortable audit. So let me just run through what happens. And this is based on conversations with a number of relocation firms who have been audited. So this is very much what happens in practice. So that it starts with you receiving either a phone call or a letter from HMRC saying, giving you a date for an audit visit to your business. And usually it will say something like, it will be a half day we will spend with you, and that they will want to check your records and also talk to your staff. Now, they will ask you to send in advance your risk assessment document for your business and also the policy document containing your anti-money laundering procedures. So you fire these off in advance of the audit day. On the day of the audit itself,